you all very much. Can everyone hear me okay? Okay. Thank you all for being here this afternoon. This is the fourth and final time I will present this. I've been asked by the staff to say thank you because they're tired of seeing my face on the TV outside advertising this. So I appreciate y'all being here. How many of y'all knew that I was available to members? Okay, so there's a few of you. The good news is I am always available. 50% of my job is to help the association with the business of running the association, the human resources, the contracts, the management of it, and then the other 50% is to assist you. I provide the same call center information as TAR, but here for just our local members. So if you ever have a question, you're more than welcome to call me. If you want to email me, it'll be at the very end. You're more than welcome to do that. Or if you're ever just around and want to stop by, you're more than welcome to do so. I bring that up just by way of saying we will have plenty of information to cover. I'm going to try and cover it all as best as possible and as quickly as possible so that we have questions. But if not, again, you're always more than welcome to come by. So the objective was going to be top 10 liability issues, but you'll see I had to scratch out the 10 and write 9. I'll explain that in a second. When I was preparing for my presentation, I wanted to give y'all useful information. And rather than take the information what I thought would be useful for you, I went ahead and did some research. My first point of research was TAR. I called TAR and I asked them to provide me a list of the top complaints or violations for the Code of Ethics. They gave me that list. I went to NAR. NAR every 2 years puts out a legal scan. The next one will be done in 2013. The legal scan seeks to get the opinions from all agents around the country. It looks up all the common legislation that's occurred and as well as litigation that might have happened. Based on all that, they synthesize the information and decide what top legal issues are affecting agents. I also went to TREC, pulled the last 3 years' complaints, and I looked at the charges or the complaints that were filed, and I used that as part of my information. And lastly, and most importantly, I used brokers as a resource. I thought since they have boots on the ground, they can provide me the best information as to what they see happening amongst the community. So I really do appreciate those brokers who are here who provided me information. So thank you. As I mentioned earlier, the purpose, I had hoped to have a top 10 kind of David Letterman style, with an ultimate number 1, but we didn't. After synthesizing all the information, we only had 9. So there will be no top 10, there will be a top 9. The overall theme for all of these will be advertising, contracts, and communications. Within each of these, there is subparts, but overall, these are the 3 themes that I saw were affecting everyone. I wouldn't be a lawyer if I didn't provide a disclaimer. My disclaimer is that all characters appearing in this work are fictitious. Any resemblance to real persons living or dead is purely coincidental. People call me all the time. I have conversations in the hallway of people who have asked me for assistance. I think those are valuable stories to share with you because they are what's happening. I have changed either the parties' names, facts, just so that you can feel comfortable that if you ever come to me, even though we don't have an appropriate attorney-client privilege, I will extend you the same courtesy that if you tell me something, I'm not going to share it with everyone. So just wanted to put that out there. The number 9, working our way down, with advertising is print advertising. Who here still does print advertising? Okay, a good number of people. The number 1 complaint filed in TAR was advertising. This encompassed print, this encompassed internet, as well as the advertisement that you would do on property. It was always around the status of the agent being disclosed and brokerage information being disclosed. Anyone here advertise in the newspaper? Show of hands, a couple of people. Okay, great. Part of my research went through the Sunday paper for the last couple of weeks, and I pulled a couple of ads. I created this one up there as a resemblance of what I had been seeing. My guess is that if I would have called a couple of these numbers, it's just 123 Any Street 4-3, Great Home, North Side, 125,000, my name, and then a phone number. I'm going to speculate that if I would have called a couple of these ads, I probably would have got a hold of an agent, and that person wasn't necessarily disclosing the information they needed to. But there were a couple of people in the newspaper who would put their name, kind of like me, Gilbert, and then they would put comma, and they would put agent, or comma, and they would put broker. that would still be insufficient with regards to the rules. You would need to disclose your brokerage information, not just that you are yourself licensed. The other part of print advertisement was in magazines, and I would go, for whatever reason now I find it very enjoyable to go to gyms and pick up the real estate magazines and go through them and see what kind of advertisements I see. Rather than pull someone's directly, I made my own. So this is advertisement to example everything. The photo of the young lady is actually my daughter. I just wanted to self-promote her. So, magazine advertisement, same exact issue, not disclosing all the necessary information. If we were to find an ad like this in the magazine, and I think most of them had some of this information, but this was one of the bare bones. It essentially has a bunch of advertising language, and then it has Gilbert Gonzalez, my name, and then underneath it, great idea properties. Just assuming that would be my brokerage. If I was, in fact, a broker, does anyone here feel like I should disclose that even though I've put the name of my company, I should put in broker? Yeah. So a lot of people just put the name of the brokerage. They don't necessarily put comma broker, and I would suggest that you should put broker as part of it. But this definitely comes into more of an issue when we talk about agents. If I am an agent, does anyone see a problem with it this time? The problem is going to be, it seems like I'm the owner of this brokerage company, correct? And when we talk about advertisement rules, what we're really talking about is protecting consumers. We want to give them the necessary information to be able to locate you at the Trek website. And so if they were going to go look up Gilbert Gonzalez, and there was no great idea properties, but there was a bunch of my brokerage name, is who I'm filed under, they wouldn't have been able to find me. Right? There have been multiple Gilberts. So if this is my brokerage company, if this is not my brokerage company but the one I work under, I needed to put on there that I was an agent. How about if Great Idea Properties is my DBA? If this DBA has not been filed with Trek, then I would need to, as well as adding agent, I would need to put somewhere else on the advertisement the brokerage of which I operate under. But however, what if my broker has filed with Trek, my DBA? Well, then it would be okay to operate under just Great Idea Properties. But the important thing is, if there is a DBA, within 30 days of when they begin to operate under that DBA, it needs to be filed with Trek. Again, so that consumers can be made aware of how they can track the responsible party for an agent. Who can they call to complain to or with concerns, right? So that's what we're always trying to do, is look after agents. Consumers. I'm looking after agents. Number 8, advertising on the property. If you look at this ad, you have a for sale sign. And there are multiple examples of people calling for sale signs just like this in front of homes, and what they end up doing is making contact with an agent. The same rules apply if you're advertising for property. That property must have a sign that discloses all the necessary information. Your brokerage, that you're an agent, all that good stuff. If we think about it, what happens when a consumer calls this phone number? If they call this phone number, generally they're going to think they're dealing with the owner of the property, right? And if we talk about the owner of the property, it's an even playing field. But if they call this number and they get an agent, is it really an even playing field? I would propose to you no. I would propose to you that you guys are experts in the field. You guys have a greater awareness of the way transactions happen, and you all have an advantage over the average consumer because you're familiar with all this. So again, the rules are there to protect consumers and make them know who they're dealing with. Because if they are dealing with an agent, chances are they're going to want to find an agent too to level out the playing field. I got a call the other day by someone who had asked me if they could put a sign in their, I believe it was their mother's yard. And I said, sure, not a problem. What kind of sign? And they said, well, it's going to be the standard sign that you put in front of any home that's for sale. I said, okay, well, is the house for sale? And he said, no. I said, okay. I said, well, why do you want to put it there? He's like, well, I just want to, it's at a great spot and I want to bring in customers. I said, well, I told him the ethical rules would probably provide you with the opportunity to be creative. However, I think you're misrepresenting yourself out to this consumer. And I brought this up by way of trial. The litigator in me thought, how would this be used against them? That consumer is calling. they're going to get this agent. They're going to say, I'd like to see that house. I'd like more information about that house. And what are they going to be told? That house isn't for sale, but actually there is another house just like it in the neighborhood. Why don't you let me take you and show you that one, right? And the consumer may be okay with it, never be realized that there's a problem with that. But what if the transaction goes horribly wrong? What if it's on trial and that consumer is suing because after they moved into the house that the agent helped them buy, they're unhappy for whatever reason? I promise you that attorney's going to take that consumer on the stand and say, tell me a little bit about how you ran into this agent, how you met him. Well, I was going through the neighborhood and I saw a house for sale, so I called the number. And then what happened? Well, I called him and he told me that house isn't for sale. Okay, so he misrepresented information to you to bring him into business. Yes. I mean, from there on, it's downhill, right? So we always want to consider when we get creative with our advertisement, we need to take into perspective, how is the consumer going to receive that? Are they going to be able to, because if he would have put all the legal requirements in his sign, and he would have followed the rule that the owner of the property must give you written consent to put that sign in the front, it still would have misrepresented to the consumer this problem, right? Okay. A first aside with regards to advertising on the property. Does anyone here, when the house is vacant, leave flyers inside the house for the property? Right? This is my made-up flyer. You'll notice that it has an open floor plan, lots of natural light, and fantastic views. There's a big hole in the roof. I don't know, I missed it by not making it big enough for you guys. But a person called me and said they were having a problem with a house they sold 2 years ago, so I asked them to tell me what happened. And they told me, I sold this house 2 years ago to an investor. The investor made the decision to purchase this house based on the square footage. They had done their math and calculated that if this square footage was, 2,000 square feet, and I purchased the home for this price, when I make my investment, turn around and sell it, I can look to make this much profit. And they had used square footage as a very important part of their decision-making process. So I said, so then what happened? Well, the investor called me today and told me that they went to have the house appraised because they're looking to put the house back on the market, and in fact, it was off by 300 square feet. So I said, how did that happen? And she said, well, the investor is telling me that my flyer that I left inside the house said 2,300 square feet, that my MLS listing said 2,000 square feet, and that and then I asked her, well, is that true? And she said, yes, but in the agent remarks, I had put that 300 extra square feet. Right? So we have 3 different places with 3 different numbers, essentially. We have a flyer, we have the MLS, and then we have agent remarks. Which one are they going to rely on? And again, it all goes back to, if something goes wrong with this deal, any lawyer is going to look for any reason on why they can say information was misrepresented. And what are they going to show is the agent put something here, and the agent put something else there. So we were talking about this, and I asked, what did they want? They said, well, if I don't pay them, they're going to sue me. And I said, well, have you seen the flyer? And she said, no, I haven't seen the flyer. They won't give it to me. So I would also emphasize that if, as part of your record-keeping habits, keep those types of things as well. I think that's good information to have. My guess is none of y'all will ever be in this situation again, or ever, excuse me. If you are going to cite square footage and it is something different, I see some heads no, okay. Definitely rely on somebody else's information. What happened in this instance was the seller of the property told the agent the back room was converted and that's where the extra 300 square feet come in. So she said, okay, and she went and measured the room herself, got the 300 square feet calculation, and that's where the 2,300 came from. So she auto-populated MLS, but she created this other number. If you ever have an instance where that happens, my suggestion would be find someone else to measure, make that person have a report, put that report in Associated Docs with the addendum that says information from other sources, and then say, see addendum for issued or not problems, the square footage or possible square footage. You have more, so, but always be consistent with the one number. Let's see. Number 7. Number 7 in advertisement has been Craigslist. Is there anyone here who uses Craigslist? Great, a couple of people. For those of you who don't use Craigslist, I think you should know it's possible some of your listings may be on there anyways. And that's why I'm bringing it up. Craigslist is being treated by some people as an IDX website, and in fact, it is not an IDX website. It should not have agents' advertisements on there unless they have the listing agent's permission. If you're going to advertise on Craigslist, you need to consider it a newspaper ad. Because essentially that's what it is. It is taken over classifieds. If you go to the newspaper on Sunday and you look at the classifieds, it's like one page where it used to be an entire section. You go to Craigslist, refresh daily, numerous, right? It's a great tool. It's free, but it's being used and mistreated. So I wanted to go through an example of one of these with you. For those of you who haven't been to Craigslist, this is what it looks like. It has, this one's for Houston. If you go through it, you can see that there's several links available to you to those blue lines. And if you look down on, some of them are pretty generic. So we would just say Alamo Heights, right? And they would just, you could click on that. Or some would say Alamo Heights, 299,000, 3-bedroom, 200 square feet. Some are very specific. I went ahead and clicked on a very specific one, and I forgot to zoom that up for y'all. This is what you'll find. Would anyone disagree that this looks like for an advertisement for a very specific home? Mm-hmm. Right? I mean, it says 299,000, 4 bedrooms, spacious Texas home, 3 baths. It's a little smaller, but it says home for sale, affordably priced. See below more info with this link. So there's a little blue line right above the photo for the link. If I click on this link, it'll take me to a broker's website or an agent's website. If you look further, and I did because I looked it for this example, you'll know that that listing does not belong to that agent. It in fact belongs to somebody else. But what has this agent done? They've decided that they were going to try and get business to their website and advertise and bring in customers. So it's believed that if you, let's see if it gets there. At the bottom, right under the photo, it says, listing courtesy of Gilbert Gonzalez, my brokerage firm. If you cite that the listing is from another source, that is insufficient. Because if you think about it in the newspaper, if you were to cite just the way we did earlier, this house, this bedroom, my name, my phone number, listing courtesy of, I mean, it wouldn't work. You'd still need that person's written permission to put that ad in the newspaper. Same thing applies to Craigslist. So the suggestion being given is if you want to set up a Google search and you put in the address of your property, and Google, what it does is if that address pops up, it sends you an alert to let you know that this address is on a website somewhere, and it'll send you that link. It's used for use, but this is a good resource to use. The other thing I want to talk to you all about with regard to Craigslist is that it is the latest means used by criminals. It used to be you get an email from somebody in Africa who's trying to get rid of their $1 billion estate. If you just send them over your account number, and share it with you. My dad did that once. I was so upset. I cannot believe he did that. He's an adventurous young man. Criminals now have decided that they will take legitimate listings, just like the one we saw, or that's up there. They'll take the photo, they'll take the information about the listing, and they'll put it on Craigslist for rent. They'll post on, once they get the communication in from the possible consumer, they'll say, I had to move to New York for a job, I got restationed in Florida, any number of reasons why they're not in the state. We can do this together, I'll send you the key, FedEx, you just wire me the deposit and first month's rent, and it'll all taken care of. And consumers are going ahead and doing that. I don't bring this up by way of I don't see any liability against you all, but I do think, what I've heard is people have called me and said, Gilbert, my seller is really upset. Somebody came knocking on their door and told them that their house was up for rent and they had the legitimate right to enter. And I just think you should know that's where it's coming from, is criminals are taking information and exploiting it, okay? The resources you should do is call the local police department, call any federal law enforcement agency. They're the ones who need to go ahead and track down these people. Hopefully they'll put an end to it soon. Number 6, we're moving into contracts now. So we're out of advertisement into contracts. Does the fact that I put no content on this slide bother anyone? Okay, good. That means you're probably, when you see a blank on a contract, you fill it in. And one of the main complaints that I have seen through cases as well as brokers' information is that some agents do not complete contracts all the way. I want to share a story with you out of Austin. It involves an agent who entered into a representation agreement. If the agreement was, if I sell you a piece of property, I will get, if you purchase a piece of property, I will get 6% commission. And what they did was check the box, wrote in 6. And then the next line, I'm sure y'all are familiar, it says, if you lease a property, I get, and they wrote in 6%. But they didn't check the box. Consumer went ahead and leased a property, did not purchase, and they went with someone else. Agent finds out, calls the consumer and says, we had an agreement. We were supposed to lease a property. I mean, if you lease something through me, I was supposed to get 6%. And the consumer says, no, that wasn't our agreement. He says, well, I'm taking you to court. Agent sues the consumer, and the court goes and interprets everything. And how does the court do that? The court will look at the contract. They call it the 4 corners of the document. And that is what they look at, to look at the intent of the parties. And when you look at the intent of the parties, it will be construed strictly against the author, which would be you. So in this instance, the court said, well, the agent checked off that if they purchased a property, I would get 6%, but they didn't check off the box in front of if they leased. Therefore, we're going to find that the consumer did not have an agreement with regard to the lease of property, and the consumer will win. Not only did the consumer win, their attorney's fees were paid for, and that equaled $15,000. If that's not a really good example why you should check in every box, put in 0 if necessary, NA if possible, I would highly recommend that. For those of you who are annoyed by this blank slide, I made this one. Always fill in the blanks. Use specific over general. If you're going to talk about repairs, don't ever say repairs as cited in the inspection. Go ahead and say fix the door threshold, replacing the window, doing whatever to the roof. Very specific as opposed to general. That'll help. It's more work, but it'll probably reduce your liability if any problems come up. And always include the execution date. Execution date was one of those things that brokers told me people never put in, or it's not always correct. And with regards to execution date, I can tell you that there are 20 timelines going on in a contract. And most of them all deal with the execution date. And of those timelines, about 15 of them deal with the termination of the contract. So if we have a miscommunication on the execution date, chances are we may have a problem later down the road when we're talking about days to perform. So always stay on top of execution dates. Number 5, with regards to contracts, specialized transactions. Specialized transaction was a big deal at the Winter TAR conference. It dealt primarily with property management, but there I would also include farm and ranch and commercial real estate. If you are going to take on this type of transaction, I would suggest that you feel comfortable with the nature of the business to represent someone. TREC holds you responsible to not act negligently or incompetently. And I believe that is the code provision that they use when someone enters into a transaction where they probably weren't as knowledgeable as they should have. For example, farm and ranch. Agent called me, told me, I entered into a contract for my seller. Their intent was to transfer only the property and retain the mineral estate. That in fact did not happen. The new owner has both. That property owner who knew there were mineral investments underneath his property lost out. And that person was, I forgot what happened on, I don't think they ever told me. They never told me what ended up happening, but I promise you it probably wasn't good for that agent who really didn't do well for their client. With regard to commercial property, one person called me once and they said, I represented someone to purchase a piece of property. It was a house that is owned by a church, and the church converted it to commercial because they were running their business out of the bottom, and the top floor was still used as for residential purposes for the parishioners. When we bought the property, I told them that we were going to be easily able to turn it back into residential property. And after they moved into the property, made the transaction close, they found out that it wasn't going to be that easy, and it might not actually happen at all based on what had happened in the neighborhood. So another example of an agent just taking on something they might not or shouldn't have. And all other regard to commercial would be a person who was looking to purchase a home for a restaurateur, and that person was going to turn the home in the hill country into a restaurant because it had great views. I'm thinking Scenic Loop Cafe. And they called and they were trying to be preemptive and asked me, there's no deed restrictions, is there anything else I should do? How can I make sure that this is going to be able to be used as commercial property? And I told them the same thing as if somebody came to ask me about oil and gas. I know enough to not do it. Even though I may be licensed to be able to practice in an oil and gas transaction, I wouldn't because I'm not there on a day-to-day basis. I'm not experienced. So I suggested to them, contact another realtor member and see if they can assist you and make sure that you have done everything you need to do, or this person had already gone far enough in the transaction, but if not, perhaps they could have referred it out to someone who does specialize in commercial transactions. The number one complaint out of TREC is property management. Property management is being regulated a lot harder now, and TREC is encouraging brokers to include in their office policies that agents not be allowed to participate in property management unless it says so in their office policies. If agents are going to enter into property management, other rules include asking for permission before it can be engaged. This is what's coming down from TREC and TAR. And the reason why is because we're dealing with consumers not just on the sale, but on a monthly basis, the transaction types. And we're dealing with a problem of commingling of funds. What do we do with the rents when they're received? What do we do with deposits? Who do they maintain? When property is transferred, who does it go to? Just these types of issues. Also, there's a concern that the homeowner's property needs to be well maintained when you enter into a property management relationship. And if it's not maintained, then you are essentially breaching some of your responsibilities. The example I got from TREC was it was regarding commingling of funds and failing to maintain property. That broker's license was revoked, and they were fined $6,000. So again, it's another issue that has a strong liability, and I would strongly encourage people to be very, very cautious when entering into these types of transactions. Okay. Number 4, contracts, special provisions. If you call me and you ask me about a special provisions question, I'll tell you right now, my answer is going to be just don't use it. Don't use special provision. That's my advice. I know it's going to get used anyways, but I'm here to give you my advice. If you are going to use special provisions or you feel there's an instance where it needs to be used, I would ask that you go to the addendums that are available to you and see if one of those would be applicable to achieve the goal that you're trying to achieve. Hopefully you'll find something there that can do it, and if not, you are only allowed, or you should only be making factual statements within special provisions. The examples I've gotten are the house will be cleaned by the time of closing date, as specific as by such and such a person. Warranty to provide it by this company, such and such a person. One I would often advocate against is failing to appraise. And every time I brought this up, the prior 3 town halls, I know I've gotten some questions on it because I know the conduct or the custom is that it is acceptable. My belief is it's giving legal advice. If you tell a consumer that you can protect them legally by inserting language into special provisions that if this home does not appraise, the contract will terminate, you've given them a legal opinion on what will happen if something occurs. So if you are able to, I would suggest you can have a lawyer provide that information. The parties can agree to put something into there. A lawyer can suggest to put something into there. But I would recommend that you avoid putting anything that comes from your own creation. Okay? And I know brokerages have different responsibilities with regards to this. I will always refer people back to their brokers to see how they feel about using it. Special provisions has been used for commission information. We should not be putting commission information into special provisions. The agent who did do this with TREC was fined $5,000. I would point out that paragraph 8 of the 1-4 contract states all obligations of the parties for payments of broker's fees are contained in a separate written agreement. If we put something about commission in paragraph 11, special provisions, we've essentially contradicted another term in the contract. So which one is going to happen? I mean, I hope y'all can see the problem. We're now making just this contract ambiguous, and how's it going to work? Yes, ma'am.
Where do you put bonus information?
Where do you put bonus information?
That little space gives you a percentage, but doesn't give you enough space to put plus bonus.
I've had plenty of questions on bonuses. I can tell you that they're not conditional. Bonus information, I'll have to double check. I think what you're going to want to do is look at, let me follow up with that. I don't want to give you an answer that's going to be wrong. I know where to put it, but I can't think of it just right now. Special provisions with regards to lease to purchase. I was told that for a long time, a lease to purchase would be perfectly all right if you take a lease for 12 months and then you get a purchase contract that is closing date in 12 months. My advice is you should not do this. Why? The parties' interests are not protected. A tenant who moves out before the 1-year term of the lease, that homeowner who is intending to sell their property has lost out. The homeowner who sells their property before the lease is over, now that tenant has lost out. I would also point out that paragraph K of the lease contract states, this lease should not be used in conjunction with an executory contract of any type, such as contracts for deed, leases with options to purchase, or lease options, without the advice of an attorney. So again, please avoid special provisions with regards to lease to purchase. Moving on, number three. Number three with regards to contract is option periods. Brokers consistently told me that option periods caused confusion for agents, and it was evident in some of the cases that I would read. Most of the cases dealt with time is of the essence. When we talk about time is of the essence, we're talking, that's a legal way of saying the court believes the parties have agreed that 10 days means 10 days. When time is of the essence, delivering of an option fee means in 2 days that it has to be done in 2 days. That is what that means. So I had a call and an agent told me, well, it's day 2, I'm trying to get my option fee over to the seller and I can't get a hold of that agent. What can I do? There are options to be done, but I wanted to emphasize the other agent was frustrated in the situation and the person was not going to be able to provide that option fee. So what does that mean? If I sell you a piece of property, I get money. If I give you 10 days as an option, then I need to get something. There needs to be an exchange of consideration. That is why it's important that the option fee be delivered. Because in order to get the 10 days, I have to give something, right? So that's the important part. Trek had a person who entered into an all-cash deal, emphasized to the homeowner or the buyer that if they entered into this deal, they would have an option period. And in fact, they did not check the appropriate box, as well as deliver any fee. So that agent was fined $5,000 for his problem. For his mistake. The other part with regards to option periods was been calculation of days. I'm sure everyone here knows, so I apologize if I'm being rude, but if we entered into an option period on September 2010 on Wednesday the 1st, and the option period is for 10 days, the 10th day would be on the 11th. The first is 0, the second is 1. And then we keep counting up to 10, and that takes us to the 11th. With regards to this aspect, what I would encourage you is to give yourself enough time to perform whatever it is that you need the option period for. I had an agent call me who had recently moved to San Antonio. He wasn't from Texas. He got here as soon as he could. And what he said was, I just got a mouthful from the other agent who told me I was being outlandish for requesting 30 days for an option period. And what I told him was, I believe that the culture for at least San Antonio, because I've seen a lot of contracts from San Antonio, is 10 to 15 days, 10 to 12. I said, so you're dealing with the culture. But I also told him, but it is a blank. Because it is a blank, it is negotiable. Don't expect them to give you an option period the day before closing. Don't expect to ask for a 30-day option period and not have to pay more than the standard fee. But if you know that because your party that you represent is out of state, because your party you represent has other commitments that keep them from not being able to operate within the 10 days, get more time. That'll save you a lot of time, a lot of pressure. It'll reduce your liability immensely. and it's all negotiable. It's a blank. So I would encourage y'all to do that. And the last part overlying was communications. Of all the responses I received from brokers, 95, 98% of them always spoke about communication. Communication between clients and agents, and communication between agents. And I got a lot of good examples of how this was a problem. And so that I wouldn't have to talk the whole time, I asked, we made a video. I had 3 wonderful agents, realtor members, create a video that I'd like to share with you all right now.
So tell me what you're looking for. There's a 2-story house that I know you just love for $200,000.
Well, I'd really prefer this 1-story for about $180,000.
She may think she wants this 1-story, but this house is incredible. That's what I do, sell the dream.
I just really think that house is out of my budget. I'd be willing to go $190,000, but no more.
I saw the way you looked at the house. It's something that you can grow into, and mark my words, you can get that house for $190,000. I can get any price. I know how to negotiate better than anyone. I am Sam Wright.
Hey Sam, let's hear it. It better be good. I don't have time for this back and forth. My client's getting restless.
190. Yes, 190,000. Final offer. Madison, this is the best price you'll get. Mark my words on that.
My clients will never go for that. Not if that's the best you got. There's no way.
Hello? Oh no.
Sam is always lowballing offers to me. It's like he doesn't think I know what I'm doing. What's his problem? I'm the best in town. I'm not even taking that offer to my client. It's ridiculous.
I've called Sam's office many times, and his assistant only says that he's too busy selling the dream. What dream is he selling? Buying a house too much that you don't even want? I've called you 4 times, and you haven't been taking my calls.
I'm sorry, I was in line getting you some Starbucks.
Thanks, I guess. So did I get the house?
Good news, bad news. This Butterfinger is great, and bad news is, no, you didn't.
That's okay. I didn't want that house anyways. Like I said, let's go look at that 1-story on Meadowbrook.
Excellent, but I do want to show you a house on River Mist. It's a 2-story, pool, great schools, great neighborhood.
I'm super interested in this house on Meadowbrook, but Sam keeps taking me to houses that I don't really want and are out of my price range. I feel like he's just showing off.
Hope y'all enjoyed that video. I appreciate that they worked on it for me. The agents who represented that were trying to put across what I heard from multiple brokers was that agents often speak on behalf of their clients without appropriately speaking to their clients, such as she did. She said, I'm not even taking that offer to my client. And I'm told, and I know some of y'all are appalled, but that's what everyone told me, is that that's what's happening. And they also was told that they're just not communicating between agents. The agent also, for her, wasn't listening. She said, I need this, this is what I'm looking for, and he was thinking, no, I know what you really want, this is how we should get it. And I have examples of how this has happened. The first one was with regards to a title company. An agent called me and told me that he was representing a person who was overseeing a military command, and he had given the power of attorney to his mom to enter into the purchase of a home because he needed a house by the time he came back. So the agent was representing them. He had seen a house, they had liked the house, they wanted to put an offer on the house, and they did. So they submitted the contract to the listing agent, and as part of the contract, though, they switched the title company that was requested or listed on the MLS. The selling agent received the contract, signed off on the contract, and sent it back to the buying agent. And they had changed the title company back to what was listed on the MLS. The agent's calling me because they'd like to file an ethics complaint. So I asked, why do you feel like you need to file an ethics complaint? Well, they're acting unethically. I know for a fact that this agent's office is right next to the title company. They're not being very considerate of the fact that my client doesn't drive and she can't make it all the way across town. That's why I picked a title company right next to the house where it's being sold. I said, okay. Well, are we sure that the seller isn't the one who's picking the title company? Have you talked to the listing agent? No, I haven't talked to them. I'm just absolutely positive. what do we have here? Do we have a contract? Absolutely not, because they submitted an offer, it was approved, and then it was returned, but it was changed. Yeah, so it's a counteroffer. What could happen? The seller of the property could lose out on the deal. The purchaser of the property could miss out on their house. What he had told me he did was he called, I think he emailed the son and said, I don't think we should go forward, or I think the agent over there is acting irresponsibly. I don't know what you want me to do, but I recommend that we counter and put the title company back to where it's where I wanted it. You know, the problem with that is the person really wanted to buy the house and the other person really just wanted to sell the house, and I didn't hear anything about any of the parties being the ones who motivated this discussion. This seemed like it was all about the agents who were just not communicating. The other example I have about this was with regards to purchasing of a home under VA financing. The agent was representing someone who she knew did not have the means to do repairs for a home. She allowed her to make a bid on a house that was to be sold as is. So I said a bid, an offer on a house for sell as is. They entered into the contract, they had passed the option period, and they were trying to negotiate repairs. And the seller was insistent, I'm not doing repairs, the house is for sale as is. The agent said to the buyer, I think what we should do is ask to extend closing another 30 days, see if we can negotiate them to in fact do the repairs. And the buyer agreed, but as part of that agreement, she had to agree to make the escrow non-refundable. I anticipate that the seller, who insisted was as is going to stay as is, and that the purchaser is going to miss out on a contract because they can't afford to do the repairs. The VA is going to require them to be done, and they're going to lose out on their escrow fund. It was another example of the agent was just not paying attention to the needs of their clients and not being aware that they weren't going to be able to really follow through on this type of transaction. So communication amongst clients was one of the number one reasons that brokers were informing me about. The other one was just about communication amongst agents. I had a conversation with someone recently, and I was talking about a situation that was going on, and the lawyer and me referred to them as opposing parties, and I was quickly corrected and said, it's not opposing, we're cooperating. And in fact, it's true. If we look at the ethics rules, it refers to everyone as cooperating. The lawyer and me just refers to everyone as opposing, because as far as I know, very few people are happy after a divorce case goes to trial, even though last time somebody raised their hand, so nobody did this time, thank you. And I just think that it's important to keep that frame of mind, cooperating agents. You have the ability to assist the buyers and the sellers achieve both of what they want. It's not someone enforcing something on someone else. You can still cooperate enough to where everybody wins, right? There is no law, there is no rule about cooperating or communicating well with other agents, but I thought it would be the number one reason to emphasize to reduce your liability, because I think it would have worked in a number of the examples that we've talked about. If we talked about the square footage today, if that agent would have just talked to the other agents and said, you put a contract on this house, it's listed at 2,000 square feet, but by the way, be sure and look at associated docs so you can know about the conversation about the potential other square feet, right? If we think about the guy from out of state who wanted a longer option period, all he was trying to do was advocate for his clients. Did that seller, listing agent, lose out on a potential buyer because he wasn't able to work with the other agent and offer him an option period that was reasonable, make him pay the just consideration for that, as well as the title company example. Buyer could have missed out and seller could have missed out just because they weren't talking to each other. And the best example I have from this, and I get a bunch of good examples, is somebody called and they had a property they sold for an investor from California. They didn't want to come to Texas, they didn't want to have anything to do with the property after all, so they just wanted to get rid of it, and they found somebody to purchase it. Before they were purchasing it, they asked to repair the garage door. In repairing the garage door, apparently there's some speculation as to how it happened, but the garage door opener went missing. All of y'all know that the garage door opener is attached to the house, so it should have transferred. So after the walkthrough, after closing, nobody looked up apparently, they found out the garage door is missing. The purchaser of the property is upset. The agent's calling me and saying, The sellers in California don't want to return my phone call. They don't consider anything this their problem. I'm the one who has to deal with it. And the agent on the other side proposed, we need to come up with $200 for a new garage door opener. You put in 100, I'll put in 100. Seller will get their garage door opener. Do we avoid litigation? Absolutely. Do we avoid any Trex complaints, TR complaints? Absolutely. I think communication is the #1 benefit or advice I would give to reduce your liability. So those are my top 9. I think we have plenty of time for a couple of questions. So if anyone has anything, I appreciate it. Yes, ma'am.
Back in the very beginning when you talked about a DBA.
Yes, ma'am. DBA.
Yeah, doing business. And I have another business that we've been in 40-something years. When we have a DBA, we're also expected to list it as a assumed name in the courthouse, and that's good for 10 years. Because let's say you have your DBA, and there's another Gilbert, Gonzalez, or something. Having it listed as at the courthouse protects you from having someone else take your good name or your same name. Are we required to do that also?
We can talk about that a little bit. So somebody called me the other day. They had entered into a new business arrangement. They were changing their name to be more in line with the business that I'm trying to make sure I give it without giving the brokerage name. They were changing their business name, and what they did was they filed something at the county courthouse. And they filed it in every county in the state with the Secretary of State. But they had not filed it with TREC. And in fact, when they went to file it with TREC, they found out somebody else had already was operating under that name. Yes, I know. The way it ended up working out was the person who had been operating under that name and that had been filed at TREC, even though they had not filed in all the different counties, had, if you will, de facto given notice, had held themselves out and had claimed that business name. So they were threatening to sue the new person. I think the TREC one is going to be the most important one for your advertising. And I think that if you're going to file it with the county, hopefully it'll match up. If there is a conflict, I think it's something that goes to the facts. You have to decide who had it first, longer, that type of thing. Any other questions?
I have a question.
Yes, ma'am.
On your topic of lease to purchase.
Yes, ma'am.
If you have a client who wants to do this, and I recently had, your recommendation was not get involved, which I have not. But trying to find a lawyer to handle this for him has been very difficult. I understand that it's possible that they would need a contract for deed, and only a lawyer can do that, right?
Correct.
So what do you recommend?
Have you tried our affiliate members?
Yes.
The 4?
Yes.
And none of them were able to do it?
One of them possibly. I wanted to give them 3 recommendations.
You want to give them 3 recommendations?
Dan Brown, Tom Basler, Warren Barrett.
I'll talk to you.
Yeah, I'm gonna go real quick. Gilbert's probably smarter than me to not answer the question, but you asked about where to put a bonus, and I have to be careful because sitting beside you is somebody who's very mature, Al Karras, in real estate, managed for a long time, and also Florence Terrell and Dwight Hale, who's our past TAR president in the back. But I think what you see most of the time is that where you write a 2 or 3% or whatever the co-broke is on page 9, after you write that percentage of co-broke, then you're going to write the bonus in there. I think that's where you see it most of the time.
Okay.
I'm not saying that's the best place, but that's where you see it the most.
They need to change the contract then.
I'm sorry?
They need to just add a line in there for those.
Yeah.
So,
Yes, ma'am.
You said not to write anything in special provisions, but then you said to use an appropriate addendum.
Yes.
If, say you have a situation, and this is actually happening in my office right now, the sales price on the property is $1.2 million, and the buyer is putting down $600,000, but they don't think the property is going to appraise. Because of the loan to value, the lender doesn't care, but the buyer does not want to overpay for the property. What addendum could you possibly use?
My hope is that if somebody's going to buy a $1.2 million home, they're not going to object to hiring an attorney to protect that purchase.
Okay.
I would say that as part of the third-party addendum, every one of those provisions provides for a failing to appraise clause, right? Except for the top one, the standard one.
Not the convention.
Not the conventional.
Not conventional.
I would say that that's on purpose, because in my experience of looking at legislation, we always look to the legislative intent. If something's left out, it's usually on purpose, and I think that's on purpose. I think we assume that consumers are going to be smart enough to enter into those transactions carefully. So my advice would be to hire an attorney, especially in those places, because I understand completely. For anyone who puts a lot of money down, they are taking a greater amount of risk. Absolutely. And I think it should be protected. My advice is just you not be the one who tell them how to do it. My advice is to get somebody else to.
So just basically hire an attorney to, or the contract has already been agreed to.
Yes. I mean, if the contract's already been agreed to,
It can be done in a.
yeah, we can talk about it afterwards, but yeah, I would hire somebody. Yes?
Hers has already been agreed to, but another way you could handle that is to actually do the appraisal during the option period.
That's really the best way to do it, if you can do it that fast, because then you don't have to write any wording in, if you can do it that way.
Or give yourself more time in the option period. Yes, ma'am.
I have a question going back to the DDAs. Is it a requirement to make a disclaimer as to what the legal name of the company is, like so-and-so company is a limited liability company in the state of Texas, doing business as, on your advertisements?
Do you have?
If you filed with track, you still have to make that disclosure on your advertising. I have an attorney advise me to do that. That's all.
My guess is he was going under liability responsibilities. So if you filed for advertisement purposes, we're talking about holding ourselves out to consumers. And I went and I looked at the rules, and all the rules about disclosing, brokerage are all under advertising. But my guess is what he's talking about is if you're sued, have you held yourself out as a limited liability company? And I think in order for legal protections, you should hold yourself out as that, so that way when people, to hold yourself out as a limited liability company, everybody knows. I think that would be the purpose of that.
Okay, we have time for one more question, if there's any others for Gilbert. If not, Gilbert, thank you very much. Appreciate it.
Thank you all.